Hello, welcome to Legislative Report. I'm State Representative Kate Harper of the 61st District in Montgomery County. The House Children and Youth Committee, of which I was recently appointed chair, held an informational meeting in March to explore the state's adoption laws. Nothing is more basic to the health and welfare of children than having a stable home with caregivers who love and support them. We want to make sure our laws in Pennsylvania facilitate that type of environment as much as we can. Following are excerpts from this informative meeting, which included testimony from adoption experts and a discussion of 3 legislative proposals designed to support more successful adoptions in the Commonwealth of Pennsylvania. The Children and Youth Committee is looking at adoption laws. We have a number of bills on the docket that are in our committee, and we thought that it would be best to start with an informational session where the committee understood the issues with the current laws and what the current laws are, and so that we can then discuss some of the requests that are pending in our committee. This is not a voting meeting, but it is nonetheless a very important meeting. And the House is not in session this week. We are doing appropriations hearings, of course. So it's very good that so many of my colleagues have come to Harrisburg to join me for this morning. I'd like to ask my co-chair, Louise Bishop, who has much more experience in the subject and on the committee than I, to give a few remarks. Louise?
Thank you very much, Madam Chair. I am delighted to have the opportunity to serve with Madam Chair this morning, and I want you to know that when I discovered that I was going to have another chairperson, I was in minority and they would be in the majority. I said, dear Lord, please let me get Representative Harper. He does answer prayer. I do have her. So I'm delighted to have the opportunity to serve with her, and my interest is the same as all of you here, the interest of our children. And as we take up the adoption law today, I hope, take it up by discussing it. I hope that we can come up with some ways where we can even help our children more through the opportunity of having them adopted. So thank you. My ears are open. I am going to be working with Chairwoman Harper as much as we can for the benefit of the children, not only in Philadelphia, but in the Commonwealth of Pennsylvania. Thank you.
We have seen significant changes in the practice of adoption over the past 20 years. While our traditional private adoptions have declined significantly over this time period, our foster adopts have grown significantly. This statewide trend towards permanency has been particularly good news to vulnerable youth in Philadelphia. These adoptions, aided through the SWAN network of services, have been a critical part of reducing length of stay of children in foster care, averting foster care drift, and most importantly, providing a lifelong family for a dependent child. The recent passage of Act 101 had positive impact in a number of areas, including broadening the eligibility for adoption search work. This has increased our request for services, which we are being responsive to through the support of the Catholic Charities Appeal. Information gleaned from fellow Catholic Charities agencies in Pennsylvania indicate like thoughts on the broadening of the search-related request. Further, forwarding background material to the statewide registry is seen as a definite plus, although this remains a work in progress due to the technology startup matters. Second, the initiation of written open adoption agreements has been a positive factor. We have found that most birth parents request ongoing contact through pictures and letters more so than direct visits. Adoptive families have welcomed this. This has been a particularly strong asset for older adoptions through the foster care system, as it is now legally binding and meets the older child's needs and wishes to continue contact with his birth family, his or her birth family. In Philadelphia, this open adoption work is completed in collaboration with the county case managers, although I understand the practice varies from county to county. It is also important to note that the SWAN network in Pennsylvania remains an important partnership for us. Recently, we have seen significant growth through child preps, child profiles, family profiles, and related SWAN work that ensures a solid transition to permanency for youth in our care. These programs accompanied with sufficient funding, again underline the vital work that the state is doing to ensure permanency for its most vulnerable children.
I've had many opportunities to talk to other professionals from other states and to compare our laws with the laws of other states. And in some respect, our laws are superior to others. However, in most cases, we lag far behind in creating an atmosphere where the child's best interest is foremost. In 1987, President Reagan appointed me to a White House task force on adoption, which gave me the opportunity to review and discuss adoption laws from other states. And in the early 1990s, I was appointed as a member of the drafting committee for the Uniform Adoption Act by the National Conference of Commissioners on Uniform State Laws. And today, with the use of the internet and other means of communication, adoptive parents are connecting with birth parents all over the nation. It's no longer birth parents and adoptive parents looking for each other within the Commonwealth. A large percentage of adoptions cross state lines, but there is no uniform law to address the various issues that arise in those adoptions. We have uniform laws to address every conceivable thing that happens to our lives. We have uniform laws to address banking, commercial ventures, almost anything that affects our lives. However, with respect to adoption, which affects the stability and the permanency of a young child, we have 50 different state laws, all of which are completely different in how and when a birth parent's rights are terminated and when adoption can be final. After working on the Uniform Adoption Act for over 5 years, only one state, Vermont, has enacted it. A multitude of other states have enacted portions, and Pennsylvania has enacted portions of it, but not all of it. But to date, there is no uniformity across the nation. And that creates a lot of problems with many, many adoptions. Now, with respect to the two House bills that I was asked to review, overall,
committee members, you have them in your packets.
Overall, the amendments are good ones, I believe. However, with respect to House Bill 449, it does restate a portion of the previous law that I believe hinders most birth parents from obtaining counseling. I'm referring to the language in 2505.1b that states that any parent or presumptive father can obtain counseling who is unable, quote, who is unable to pay for the counseling or will experience substantial financial hardship as a result of payment. I have seen counties require that birth parents complete all sorts of forms to essentially qualify for indigent status before approving the payment. Some even require them to file a petition with the court. Most birth parents will not go this step with this process due to the complex procedure in applying for free counseling. Others will simply not be qualified because I've seen in a case where the birth mother worked at McDonald's at a minimum wage, and the court felt that she wasn't going to be substantially financially have a hardship. So most birth parents will not seek the counseling under this act. The counseling funds, which have been in existence since enactment of the current law in 1992, have rarely been used. At one time in the late 1990s, I discovered that the Bucks County Fund had over $500,000 sitting in it, and it had never been touched since 1992. Our local court administrator indicated to me on Monday that in her 12 years as a court administrator, only one application was ever presented to access these funds.
The Pennsylvania Adoption Exchange is one of the features of the Department of Public Welfare that works very good for kids. For many years, it was a kind of black hole. You didn't know what was going on there. Kids might get registered in the system. Kids' photos were placed in a binder, and nobody ever knew where the binder was. And it was quite literally that difficult to engage. And yet it was the kind of marketplace, if you'll forgive the term, it was the place where folks would go to find kids whom they want to adopt. Now, of course, with the advent of the internet and a much more communicative world, it's working a lot better. Along with the Pennsylvania Adoption Exchange was the creation of the statewide adoption network, SWAN, now called the Statewide Adoption and Permanency Network. SWAN is another really good device in its most recent iterations, which is probably the 4th iteration of it over time. But by my measure, it's working pretty well. Jim and the folks at CSS are SWAN providers and could tell you more about SWAN and how it works. But this is where we go for public adoptions. So Sam is a private adoption lawyer, works in a law firm, and deals mostly with Joe and Mary Citizen who want to adopt a child, either from a stranger or maybe from their sister. That's what we colloquially call private adoptions, the world of private adoptions. Public adoptions are those kids who come from the children and youth system. Typically, a child's been removed from the care of their parents because of abuse or neglect. And the situation which led to the placement and other needs of the family have not been resolved over a period of time. And so the construct of federal and state child welfare law is you give it so much time and now you have to move on. We call that permanency, moving them to a new legal home. That permanency, adoption's the most classic form of that. There are others. So this is the world of public adoptions. As you might imagine, there's lots of kids waiting. As you might not imagine, it's hard to figure out exactly how many are. As you sit here today, I couldn't tell you, and I'm not sure even the Department of Public Welfare could tell you how many kids are waiting to be adopted in the public welfare system. You should know this. We all should know this, because accountability and data should drive how we drive this system. And that's a question that I'd have you ask them and get to know more about.
Under current state law, can the birth mother sign a consent prior to the birth, or must she wait until after birth?
Birth mother must wait 72 hours.
So
at minimum of 72 hours. She doesn't have to sign at 72 hours. And that's one of the things with the 96-hour, it might be too short of a period of time, but she could wait 2 weeks before she signs the consent, but she can't sign it before 72 hours.
I understand. Thank you. The second question that I had was with regard to the counseling, and I appreciate the lengthy kind of dialogue that we've had about it already. And it seems like, from your testimony, there's a need that has not been met. And just thinking about how this was certainly, traumatic and a very significant milestone in anyone's life, do you think it would rise to the level where we should mandate the counseling and then allow people to opt out rather than say, well, if you want it, here it is?
There are states that mandate at least 2 sessions. Trying to remember, there are a number of states that mandate that, and they do the opt-out procedure. You have to at least tell them that it's required, and then sign documents that indicate that has been offered and they've opted out. I don't know. It's a good question, because you can lead a horse to water, but you can't force them to drink. So I don't know whether mandating counseling is going to help or not. Right now, counseling is always offered, and then you always get into the question who's going to pay for it.
I would just suggest that the panel be aware that a lot of adoption counseling is provided through private charitable dollars now, so that any pregnant woman that comes to us considering counseling, we provide intervention through BROB services. That's paid for through Catholic Charities funding with no cost to the parent. Occasionally, we're able to use real alternatives. We're working with a woman who's pregnant, adoption-minded. We can refer them to the adoption agency, and we can draw down real alternative dollars for that counseling.
I contacted a couple of constituents about this hearing to get their thoughts, and one of them came back and said, that they're very much opposed to. They don't think it's appropriate that anyone would provide housing and living expenses. The adoptive parents or an agency would provide expenses because it has the semblance of you're paying for the child. It seems to me that you're not of that mindset, and I just wondered what are your thoughts there on that?
That's a big question. You can take your time answering.
Take more than one sentence.
Thank you, Madam Chair.
I've completed adoptions in almost every state, and the vast majority of states do provide for a limited amount of housing and that are living expenses. And in all states, the expenses are passed over by the court and approved. There's a lot of different ways you can do it. In some states, and before you can even pay these expenses, they have to be approved by the court as appropriate and reasonable. Other states just allow it, and they will be passed upon at the final adoption hearing. I kind of like the first approach better, having a judge involved right from the beginning. But to answer your question specifically, working with many, many birth mothers who have had the opportunity to have some of their expenses paid, I've never seen anyone being induced to by a payment of $50 a week for food or limited funds towards her housing so that she can live. When they're in their last 2 months of pregnancy and they're without a job and they have no other place to turn to, what is good of counseling if she's going to go through all this stress about where her next meal is going to be?
The purpose of my legislation is to provide added protection for children throughout the adoption process, in addition to a more stable and a more permanent residence. My bill would provide adoption-related counseling for birth parents, which includes the understanding of the process, parental rights and consequences, relinquishing parental rights, and alternatives to a relinquishment consent or adoption. The bill would terminate parental rights involuntary for anyone who commits a serious crime against a child sibling, or another child living in the home, which includes serious body injury or indecent or inappropriate contact. My legislation would expedite the adoption process for an abandoned child by setting time restraints for an adopted parent, the search for birth parents, and the filing of a termination petition. In addition, the legislation provides criteria for required notice if a birth father's whereabouts are unavailable or unknown. The petitioner must take reasonable efforts to locate or identify the father in order to provide the notice or serve the notice. I feel it is important to establish a criteria for the courts to consider in determining whether the petitioner's efforts are sufficient, whether they went far enough or did all they could. The bill would do just that because it would remove the reference of a home study and replace it with a family profile. The family profile would require state and federal criminal clearances and a child's abuse checks for any individual being considered as an adoptive parent.
This ties into, I believe, Representative Bishop's bill. We briefly spoke before about, we have all these children available for adoption here, and yet we have people going overseas to get children. A couple of my constituents went to Russia, adopted 2 children, spent $75,000 to get each child. And we have all these children here. And I'm thinking that, well, part of the things they told me are the reasons for that is there's a lot of administrative hurdles that this bill seems to maybe address in waiting periods and those type of things that prevent people from seeking children here in Pennsylvania, and that maybe that's just the number that you can select from, the type of choices you can make may be more limited than going overseas. But I'm viewing this bill, the brief time I had to review it, as a way to expedite the process and maybe make it more encouraging for people to adopt here at home rather than going overseas. Do you see it that way?
The single most reason most couples tell me they go overseas to adopt is that in most countries, birth fathers have no rights. And here, a birth mother is a biological fact. We know who she is. But the birth fathers could be anyone and could come back to haunt them years down the road. And therefore, that's the single most reason I hear people saying, well, I'll go to Russia because, or China, the babies are abandoned. And that's why I'll adopt from overseas, because of the stability factor that once they bring that baby home, they know that no one's coming to take that baby away from them.
So reducing the revocation period could have a beneficial effect on that?
That will help. I think the birth father issue is something that has to be cleared up. And I think this goes a long way towards it. We don't know who birth fathers are.
And Representative Bishop's bill has a process for, I guess, checking off that we tried all these ways to figure out who the birth father was.
That's right.
Yeah, so I would add a different frame, and it gets back to the supports we give to the adoptee and the adoptive parent. The children that we're talking about, whom it's hard to adopt, and for whom we clearly need to remove some obstacles, folks have a sense, well-founded or not, that that child comes with a history, and that history may explode on them, right? Child came from an abusive background, she's going to be troubled when she's older. Well, we can't change that history, but we certainly can set up the supports for that family if and when that happens. What we know about international adoption is that we don't know a lot about the kids, and some of the same kind of sleeping giants lie there, right? So it's not like we have this panacea. The other frame I'd simply offer that isn't necessarily so popular in the discussion about domestic adoption is that kids from China are kids too. And were they not adopted, they will live their lives horribly in orphanages and in other sad situations. We have all undoubtedly in our lives met families who have adopted kids from overseas, and we know how marvelous that can be. And so I don't think the line has to be a nationalistic one. It has to be about removing obstacles and about making adoption as easy as possible and as successful as possible for as many children and as many families as we can.
I'm learning as we go, and I appreciate your expertise here on the panel, and kind of returning to the theme of one of the previous questions I asked, talking about permanence, and then this question of birth fathers came up. Could you explain to me and I apologize if the question's elementary, but how does this happen? What is the threat that an adoptive parent would be looking at if they're concerned about the laws in this country about birth fathers' rights, essentially as it relates to revocation periods, et cetera? So even past the 30 days, if at some point in the future a birth father were to come forward and say, wait, that's my kid, does that kind of reopen a Pandora's box? Or how does that work with regard to an adoptive situation?
So birth fathers' rights are terminated when birth mothers' rights are terminated in the vast majority of these situations. Putative fathers and unknown fathers are added to the equation, to the order. So all the rights are extinguished at that moment. So we're not talking about the guy who shows up much later, except every now and then you'll see in the news the guy who was not told because of some fraud by the birth mother. Okay? Very exceptional, very rare kind of situation. They make the news. They're not the types of things that happen very frequently.
But if that happened, Frank, I think Representative Gabler's question was, if the putative father shows up, let's say 6 months later, never having gotten notice that the baby existed and was available for adoption, what happens in the law right now?
Okay. Well, if the adoption had not yet been finalized, he would be able to file a claim, and if he's successful, then the mother's rights, which would have been terminated most likely by then, that order would be vacated, and then they would have a decision as to whether or not the adoption goes forward or not. Every state, including Pennsylvania, has a putative father registry. In many states, those registries have teeth in them. Our registry does not. In 1980, around 1983, the United States Supreme Court in Lair versus Robertson stated that if a state has a putative father registry and the father has not registered prior to birth or prior to the adoption, then he loses his rights automatically, and no notice even has to be given to these guys. They haven't claimed their right by either acknowledging paternity, going to the hospital, acknowledging paternity, or filing some type of action to declare parentage. So, and these are the fellows that we're looking at who have basically dropped the birth mother in the middle stream, and come back a year from now and say, "Oh, I just found out about it." So we have a putative father registry. in which every county really, or basically Pennsylvania, does not treat it the way other states treat it. In Pennsylvania, we have to find out whether or not a father has made any claim through the putative father registry. It takes about 8 weeks now before we can get that after a child's birth, before we can get a letter indicating whether a claim has been made. In my 35 years, I've only had one person make a claim. And that's basically, I would think, because fathers don't know how to do it. It's just not publicized. Under Lair versus Robertson, if no one has made a claim, then the court really should enter an order terminating all unknown fathers. They don't do that. They just basically, most of the courts that I've been dealing with have just ignored that. I hope we could maybe, and none of this legislation addresses putative father registries, but I think that would go a long way in clearing up this issue about a father who is just out there and comes back.
And what we would do would be provide, if you didn't sign up on the putative father registry nor show up in response to any of the notices that we send out, your rights are terminated, and a later claim would not be heard by the court?
You're right.
Okay. Understand?
Yeah.
Yeah, I believe so. So just to clarify, you had stated before that one of the reasons why adoptive parents tend to look overseas is there's this disparity. Mr. Cervone, you said that the putative father situation is an exceptional case, but it's still, I believe, it's an exceptional case.
No. The defrauded putative father.
Defrauded,
case,
okay.
Who's just coming out of left field later. No, this much more frequently happens in a children and youth situation.
Okay.
It's not atypical at all. Because it's such an elongated service period. So you have a mother who has not identified a father. You have, maybe she's named a father. They take a while to go find him, and then he's ruled out by blood test. So now they go back to the mother. Well, who else might it be? They didn't work so thoroughly with her the first time around, or she wasn't forthcoming in the ways that some people will be less than forthcoming for whatever other reason in their life. And now we're a year into the dependency case, and the child's been living in a foster home, and that foster home, is feeling like they'd be interested in adopting, and we really like that. We want a family, in a sense, that can go both ways. They're willing to work with reunification, but they're also willing to adopt, right? This is ideal situation in child welfare work. So, and now a year later, there's a new guy on the scene. That's what I mean.
Okay.
And that's almost unavoidable without some very clear requirements and some, in a sense, scrutiny for the social work practice about search. Let's find these guys early, and let's get the children and youth case done.
Right, and in one sense, Representative Bishop's bill goes into that process.
Right.
Let's find these guys process.
Let's find them and get them.
So, well, thank you very much. I want to thank our panel members for coming today. They were James Amato, the Deputy Secretary for the Catholic Social Services in Philadelphia, who brought with him Teresa Thompson, the Administrator for Foster Care and Adoption Services, and Bob Monturo, Supervisor of Adoption Services for the Archdiocese of Philadelphia. Thank you very much for coming. We also had our expert adoption attorney, Samuel Totaro Jr. Esquire from Bucks County, and Frank Cervone, also an attorney and an expert from the Support Center for Child Advocates. I want to thank the committee members for coming on a non-session day. I think that we had a good discussion. To sum up, I think we have a lot of children who are waiting for adoption, and we need to take a look at the laws that we have and the bills that are in front of us to see if we can make that process easier and get more of these children into permanent homes. So thank you all for coming. Well, you've been watching a meeting of the House Children and Youth Committee on the topic of adoption. And that's all the time we have today for today's program. I'm State Representative Kate Harper, Chair of the committee. If you have any questions about what you've just seen, feel free to contact me at my local office or through my website. The information will be shown on your screen in just a moment. Thanks for watching. Join me again for Legislative Report.